All right, good afternoon. Welcome to the webinar here. I hope everyone on here is having a great, well, for those of you that were off yesterday, have a great start to your week today, and those of you who weren't off yesterday, like myself, are, you know, enjoyed, you know, what you could have yesterday and are having a great start to the rest of the week so far. We do have a lot of great information that we're going to share with you today. We are fortunate enough to have a special guest on us here to share this information with you and to make sure that you got your human resource systems in place for 2016. We know there's a lot of stuff going on in the industry, and sometimes it can be very overwhelming and challenging for us to grasp. So we want to provide, some great tools for you to get a little bit of more clarity on some of these things, and maybe some things that you don't know about, some understanding about them as well. Um, so we do have a large crowd on this webinar, and I see people are jumping on left and right, but we only have this special guest on for a limited time here, so we're going to jump right into the webinar right now. Our special guest today is, let me introduce myself. For those of you who don't know me, I am Tony Farrar. I'm the Director of Business Development.
Enterprise. This is Nick speaking. How can I help you?
Here at Hurricane Marketing Enterprises. Nick, are you on there? Oh, sorry. Tony Farrar, Director of
boot camp in New Orleans. That was last year. The upcoming boot camp.
Excuse me, folks.
The upcoming boot camp is actually.
Sounds like we have an interference, Tony.
Mm-hmm. It is $6.99.
Tony, shall I speak it from here? All right.
Let's try. Sorry about that. We had our backup computer, Nick in the office here. He always has we always keep a backup just in case something happens to one of our computers, but he didn't have himself on mute. So, all right, let's rock and roll here. I would like to introduce, without further ado, Mrs. Anne-Lise Gere. She's a HR consultant specialist and independent advisor. Back in October, I met Anne-Lise at the Virginia Personal Care Services Association conference, where both of our businesses were vendors. And we started up a conversation about all the stuff that was going on in the industry, and that kind of gave us the idea to put on this webinar for you guys today, and share a little of the insight. Anne-Lise is a very special woman. She's the first person I've ever heard tell me that she has a passion about HR and working in the HR industry. As far as that, I have no desire for HR, and I've never heard anyone say that they've had a desire for HR in my life before meeting Anne-Lise.
Easy there, Tony.
And
it's a great profession.
Yeah. But as I continue with our conversations, and as I continue to speak with Anne-Lise, I can see that she has the same values and integrity that we share here at Hurricane Marketing Enterprises, and that's we ultimately want to help people. We want to help them to get the best understanding of the resources available and the best information, so that they can focus on what's most important to them in growing their business and providing care for those that they service. So without further ado, let me introduce to you Miss Anne-Lise Gere. Take it away. She's going to share some more information about herself, and then get into these HR topics that we all been waiting for. Anne-Lise?
Okay. Thank you, Tony. Yes, I have been working with the home care industry since 2012. And actually, the home care industry came and found me in 2012, a franchise of Visiting Angels, and a little shout out to those of you on the call who are franchisee of Visiting Angel, came to me and asked for help with their employee handbook. And over the years, I've worked with a variety of home care providers, private duty, people in franchise, people doing some private duty, some Medicare. So really the full spectrum of the home care experience. I work on special projects, I answer policy questions, and sometimes those tricky employee relation situations. My clients typically have HR staff on board, but those HR professionals usually are very busy doing the day-to-day hiring, firing, payroll, employee relations. And I'm sure you're all smiling when I say that. And when there's more work or specialized expertise required, they come to me. I work with agency owners as well as administrators. And for today's webinar, we're going to talk about 4 topics, 2 of which are related to pay. Coming back to the topic of overtime pay for caregivers, this was implemented back in October, but I know many of you still have questions. Another change that will impact overtime pay, but this time for probably your office staff, the definition of who is a manager or a supervisor is likely to change, and I think you need to learn and be prepared on this one. We're going to talk about a campaign called Ban the Box, a catchy word that has impact on how you do your recruitment. And finally, touch upon the Affordable Care Act, help you understand whether you should pay or play. And obviously, the Affordable Care Act is a very dense piece of legislation. I am not trying to impart full knowledge here, but I want to put some basic information in your hands so you can start thinking about it. Tony, anything else on your end?
No, we're all ready for you to jump into it here.
Okay. A few words about what I would suggest for our audience today is make sure you take notes. This is pretty dense, and although I've tried to make it as simple as possible, some of it is not simple, and I think taking notes will allow you to really focus and get the maximum value out of it. Social media, email, any other distractions that might be on at this time, turn them off. And do yourself justice if you're investing the next half an hour to be with us. Just focus your full attention. I think you will be well rewarded to get the maximum value out of this time. Don't forget your workbook. If you're taking notes, keep your notes and your workbook together. I think that's going to come handy for future reference. And finally, if you have questions, we will try to answer some of your questions. And if you've ever attended a webinar, you're probably very familiar with the question box. So you type in your question, and Tony will be your voice to share those questions with me and the rest of the audience.
Yep.
Some basic disclaimer and a warning. Usually you see that as the attorney made me do that. The information contained in this webinar is not legal advice. I am not an attorney. I'm an HR professional. And so this is shared for education purposes only. A warning for you, because I know we have people from all over the country. HR is heavily influenced by state and local legislation. So make sure you're aware of those specific situations that apply to you, and always talk to a local attorney before making any drastic changes to your employee handbook or to the way you handle your employees. Tony?
Yes.
So we're going to talk about your HR systems for 2016 and starting with the two topics of pay, overtime pay for caregivers, and what is called the change to the white collar exemption. Let's start with overtime pay for caregivers. It was truly a saga over the past almost 40 years, really. And the reason why I bring this up is because in my practice, I sometimes get the question, which is why do home care employers, why didn't they have to pay overtime when their employees, their caregivers, worked more than 40 hours a week? All other businesses in the nations are subject to overtime. And you have to look back to 1973, and it's when Congress actually passed what was called the companion exemption, and it was exemption from overtime. In 1973, home care was basically a person-to-person business. It was not even a business. It was very often an informal arrangement where a family member or a neighbor would take care of an elderly person. Fast forward to 2016, we have an exploding number of third-party home care providers combined by an increasing aging population, and you have what you all are very well aware of, which is a growing sector of the economy. And so Congress, and well, actually not Congress, let me correct that. The administration in 2013 decided to put an end to this sort of special a special situation that the home care had enjoyed for 40 years and put an end to the companion exemption for third-party providers. In 2014 and 15, if you're like me, you probably followed blow by blow the series of legal court battle, legal challenge that ensued this announcement. While this was happening, there was a stay of execution, which meant that basically nothing was changing. And eventually, in October of 2015, the DOL basically got the legal clearance to implement the rule. And starting really now, early 2016, the Department of Labor, the DOL auditors, are going to start enforcing and in their audits to check whether home care providers are indeed paying overtime to their caregivers. So really, what is the overtime for caregivers? Well, first of all, you need to be able to justify that you pay minimum wage for all the hours worked. The overtime comes in addition to that if somebody works at least 40 hours a week or 80. Often in the home care industry, you hear people mentioning 80 hours, so that's for the 2-week pay period. So if your 2-week pay period, if somebody works more than 80 hours, any additional hours would have to be paid at time and a half. Another change which may have had an impact for some of you is that the living caregivers no longer benefit from an exemption either, and they are subject to the same requirements of minimum wage for all the hours worked and overtime if they work more than 40 hours a week. You have to also put this in perspective with the fact that there is a growing pressure to increase the federal minimum wage. So the low end of the spectrum is $7.25 per hour, and that's the federal minimum wage. But it can go as high as $11.50 in places like Washington, D.C. Actually, the state of California and the state of Massachusetts, they already have a statewide $10 an hour minimum wage. So you can see that there is really a push to increase the minimum wage. And in some localities, it can be as high as trying to go for 15, and that was a slogan you may have heard last year, 15 and 15. So $15 in 2015 was some of the rallying cries of union organizers. So what has been the business impact of paying overtime to caregivers? Well, if you are private duty, clearly having to increase your labor cost is not great. But in my experience of working with your colleagues, it is feasible for those of you who have reasonably good profitability margins. A 12 to 15% increase in your labor cost is something that can be absorbed at least for some period of time. I've also started to work with people on, increasing your fees. A lot of you have not increased fees to your clients for 2 or 3 years, and so why waste a good crisis? You have a good sort of story to tell that your costs are truly going up, and so that might be the time to bite the bullet and increase your fees.
Yeah, I want to jump in real quick. I think overall on the national level, the home care industry has only increased its rate 1% in the last 10 years, I believe it is. So now is definitely the time, and it's being justified to increase your rates, folks. Oh, I thought we had another question, but it looks like it popped away.
Okay. As far as the Medicare providers, those who provide care primarily or mostly through Medicare, well, those people have a tough time. In the state of Virginia, the reimbursement rate is $13.17 per hour, and it doesn't take much of a math genius to figure out that you cannot absorb much overtime and cover your overheads with that level of reimbursement. So for Medicare providers, those basically have come to the conclusion, unfortunately, that they cannot afford to pay overtime. And across the board, regardless of the business model, I think it's fair to say that the business impact has been that home care providers have had to limit the work hours of their providers to 40 hours or just a few hours of overtime pay. They have had to maybe increase the recruitment, which is already challenging. So it puts them in a bind, truly. This is what the industry has to face. We have a question here for our audience today. I was curious to know how your agency has adapted to the requirement to pay overtime to your caregivers. Tony, do you want to launch the poll?
Yeah, we just launched the poll. If you guys can jump on there, it should pop up on your screen. Just answer, where you guys fall in line with the question.
Yes, so we have 5 possible answers. The first one, A, is you've limited the number of hours and you no longer pay overtime. You've limited the number of work hours for caregivers, but still pay some overtime. C is you've limited the number of work hours for some caregivers and allow others to work overtime. So kind of a split decision.
All right.
Or in some cases, maybe you have been paying overtime, but, and I know some home care providers, because of their local legislation or some franchise, already decided to pay overtime pay at the beginning of 2015, and so for them that didn't change anything in October, or you haven't made a decision yet on how to handle overtime.
So we got a little over 50% of the votes in right now, so we'll give another few seconds for the rest of the people to vote, and then we'll share the results here. We do have a question here that just popped up. It says, is anyone surveying home care rates for various regions? Where can one find that info? I don't know offhand if there is a survey for, you know, the regions. I know the national survey. I believe the Home Care Pulse, they are doing a study on these numbers that should be available this coming year. So that's a resource you might want to check out. That's Home Care Pulse.
That's the one I was thinking immediately when I heard that question. I know they do in several nationwide polls, and their annual survey of the state of the home care industry has information like this. I don't know if they share specific numbers unless you're a client. I guess that's probably where the distinction will come. If you're buying the survey, you'll probably get the full data set.
All right, and then
what's the result for our polls as far as you can tell?
The results are in. Most of our attendees here say they have limited the number of work hours for some and allow some overtime. That was about 60% of you, and then the next highest was they've limited the number of hours worked and no longer pay overtime, which is answer A. So
right, and that's very consistent with what I've seen and experienced with home care providers that I work with. So I am not surprised by those results. It confirms the trends that I had seen. Okay, good.
Excellent.
So what does this mean for people who are on the call in the industry? The first thing is, because you have a requirement to pay minimum wage, and whatever that minimum wage level is for your geography, you need to be able to track the hours of your caregivers. I know most of you are already doing it, but if you were not, this is high time to start doing so. You probably want also to clarify for yourself and with your supervisors and your caregivers what needs to be recorded as work hours. So for instance, travel time. There's different types of travel time. There's what's called commute time, and there's the sort of the business travel. So commuting, I think everybody's familiar with that, is when you go to the first place of work in the morning, and when you leave your last place of work and go back home at the end of your work shift, that is commute time and should not be paid. However, if you have caregivers who provide care to different clients in different locations throughout the day, the time that it takes to travel from one client to the next is considered work time and should be paid. I know that in the home care there is an approach of doing a split shift, so somebody works a couple of hours in the morning with a client, has a break in the middle of the day, and then goes back at the end of the afternoon to help the care recipient, you know, with mealtime and the sort of bedding activities. And in that case, if the courts have always come down on the side of, if there is enough time for somebody to engage in other activities than just commuting back and forth, then that time, that commute time between split shifts probably shouldn't be considered work hours and thus shouldn't be paid. In many states, the licensure organization will require home care providers to provide ongoing training, those in-service hours. So for instance, in the state of Virginia, in the state of South Carolina, home care providers have to provide about at least 12 hours of in-service per year. Those are really work hours and they should be paid as such. So once you've sort of really identified every different scenarios of what is work hours, then make sure you update your employee handbook, and so that everybody is clear on what are the rules in terms of hours and pay.
Yeah. Anne-Lise, we got two quick questions before we jump into the next section here. One is it true if there is a 60 minutes or more between the two different shifts, then travel does not need to be paid?
And I know I've been asked that question before. I don't think you'll be able to find anywhere the actual number of 60 minutes.
Okay.
That is something that is used as a sort of a guidelines, but I would say yes, anything that is long enough for somebody to be able to go out and have lunch, go shopping, maybe in some geographies where, you know, people don't have to travel very far to go for, because there's such a high density of people. You know, it's a case-by-case basis. On the other hand, if you are in a rural geography where traveling from one client to the next it takes a long time, maybe an hour is not, you know, should be paid, because that's actually what it takes to go from client A to client B. So that's why I think you will never find anybody telling you what the length of time is, but it will depend on what makes sense based on your business and where people are and the actual travel time it takes to go from one place to the next. Does that make sense?
Yes. And then the next one is providing pay for mileage between shifts sufficient?
No, you have to do both.
Okay.
If somebody is traveling, not only you pay for the mileage, but you pay for their time as well, because it is work time. They're traveling to meet your business need as your employee.
Okay.
All right. And incidentally, you can consider applying different rates of pay, whether they are traveling or whether they actually are doing the caring, the work of home care. It sounds like an appealing proposition, but I would caution you against it, because the more the pay rates you have in your system, the higher the chances of making mistakes and having issues with payroll. So I think simplicity has a lot of benefits, and unless your care providers do spend a lot of time traveling between clients, I would not even worry about implementing two rates of pay. But it is something that is an option for home care providers.
Okay. And mileage is that required? That's by state, right? That's not national to pay mileage, or mileage is national?
You mean the rate, the reimbursement rate? Is it a national rate?
To pay mileage for someone's travel.
Oh, the requirement to pay mileage?
Yeah.
I think there's probably not a piece of legislation that says you have to pay mileage, but I think it's tricky to ask an employee to use their personal vehicle, get insurance accordingly for, you know, business usage, and then not pay them for the mileage. So, I mean, if you're able to not do, I've just never seen that that an agency would not pay mileage for their employees. They didn't used to pay for time travel, but they would at least pay for mileage.
Mm-hmm. Okay, so I know we gotta keep moving. I know you got to go here, so let's jump in real quick to the next part about the what it means for office staff.
Okay, I just wanted to quickly also link back with the workbook and the next steps that our audience on the call might want to consider for 2016 is, for instance, increase, if you're not able to pay overtime, you might want to increase your the pay rate of your caregiver in 2016, especially if you're able to increase your rate of care. Implement a time and attendance system if you haven't done so yet. Most scheduling system in the home care industry have a time and attendance. It's either a mobile app that people get on their cell phone, on their smartphone, or it could be a simple phone-in system. And make sure that it is connected to your payroll. And obviously inform your caregivers and train your supervisors of any new changes you do to time and attendance, because as soon as it starts to impact pay, you know that they are in your office questioning their paycheck faster than lightning. So moving on to the next topic of pay, which is the white-collar exemption. A little bit of maybe definition to start with. What is exempt and what is non-exempt? Well, the Department of Labor considers that all employees are non-exempt from overtime unless they qualify for an exemption. There are a number of exemptions, and some of the white-collar exemptions that are probably the most relevant to the home care industry is the administrative exemption. So your administrator, your HR person, maybe your CFO probably are considered white collar and are exempt from overtime. You may have some of your staff that benefit from professional exemption. Typically that would be the registered nurse on staff, and the owner of the company probably benefits from a white collar executive exemption. So the exemption has a two-part test, which is you need to both have a minimum salary and meet the requirement test, which is basically does your position, the responsibility in the position, is it of sufficient level that it qualifies for a management type exemption or white collar exemption. So that's sort of how it works. Let's look at the numbers now, because that's what's changing. That's what the announcement from the Department of Labor back in the weekend of the 4th of July, while we were all enjoying fireworks and good weather, the DOL came out with the announcement that they were going to increase the salary, the minimum salary to qualify for an exemption, to $50,440. If you compare it to what it is now, which is a little less than $24,000, this is more than double the salary level, sorry. So that's a huge increase, and people were very shocked when they saw that new number. Another increase was the executive exemption. It was based, currently it's $100,000. With the announcement, and when it goes into effect, it will go to a little over $122,000. So those are really sizable increases, and the announcement also mentioned that those numbers would be indexed for automatic increase every year based basically on the cost of inflation levels. So those were clearly not good news for employers in general, and employers in the home care industry in particular, I think, are probably quite vulnerable to this change for their office staff. And the area of concern is really the employees who are currently exempt but will lose the exemption when the new rule comes into effect. And I haven't said it yet, but the new rule, there is no date for implementation, but we know that the Obama administration is very concerned about implementing this new rule, and so it will probably happen this summer in 2016. No specific date yet, so that's good news for employers, is they have time to sort of get ready. So the area of concern is for those employees that are currently paid at least $23,600, but less than the new threshold, which is $54,000. And so for those, unless you're able to increase their salary, they will become subject to overtime. And so it's important to know those people, if you have any of them on staff, is do they actually work more than 40 hours a week? Maybe they do, maybe they don't. Often we're not too sure about those numbers. So what are your next steps for 2016? My number one recommendation is know the numbers, and by that I mean track the hours of all your office staff so that you know who is working more than 40 hours a week and how frequently they work more than 40 hours a week. So it's important to track the hours not just for 1 week or maybe 1 month. Try to track it for really a sizable amount of time, whatever makes sense in your business. If you have a cyclical business, you know what the cycle is. And so you want to sort of get a sense for how many hours are worked by office staff over a typical cycle. In some cases, it's 2 weeks. In some cases, it's 2 months. You know the answer better than I do. And then you can look at the numbers and see if you do have indeed a problem. Once you have the numbers, you probably have several options that's open to you. For those employees who are working consistently some overtime and are close to the 55,000 threshold, you might want to consider to increase their salary to meet the new exemption level, so you don't have to worry about overtime pay, and they'll be happy because they get a salary increase. For others, those are on the lower end of that spectrum. Try to evaluate how many overtime hours they typically work. Maybe it's not that many, and you will be able to afford to pay overtime. Another thing to consider, and it has been talked about in some legal articles, is that as an employer, you set the rate of pay, and you could consider changing the rate of pay of your employees and basically lower it so that it would overall include the cost of overtime. But that's tricky, obviously. Telling people that you're going to decrease their salary and so that you can afford to pay them overtime is
that's a tough one.
do. But I actually know here at least of one employer locally who is in the human services industry who's done exactly that. But you need to be aware of the impact of your decision. In particular, if somebody, if you do not change the pay level of somebody and they become non-exempt, for some employees that could be perceived as demotion. They have lost the status of being an exempt employee, of being part of management. Although that management term has no legal significance, it is, for some employees, it's a big deal. For others, they're going to be happy as can be because suddenly they become eligible for overtime. So that, you know, you need to know your people. Some of them will like it, others will hate it. And if you run your numbers, you probably will be able to get a sense if maybe it might make sense to keep everybody's hours at 40 and maybe add a new staff member. If your overtime hours are such that it might make sense to recruit somebody, and whatever you decide to do, it will have an impact on your organization structure. Whether you have more non-exempt employees, because at that point it becomes questionable if they can still be supervisors, and if you add staff as well, that will have an impact on your org chart and structure. Tony, any questions on this one?
Let's see here. No.
Okay.
Yep, keep going.
Everybody's probably sort of dumbfounded and a little overwhelmed. But if you do have questions, by all means, you can email me afterwards. And one of the gifts at the end of the session for people who are registered today is the ability to get a 30-minute free consultation with me. So that might be a good opportunity to ask your questions at that point. The next topic I wanted to cover under the HR systems for 2016 is in the area of recruitment and the introduction of ban the box. Ban the box is something that is related to background checks. In the US, 69% of employers use criminal background checks as part of their selection process, and truly and clearly it's mostly in large organizations. And the reason why employers use background checks is clearly to avoid risk. It's a risk avoidance strategy. So they want to avoid being sued for negligent hiring. They're also concerned about the safety of employees in the workplace if they were to hire violent offenders. And in some cases, in industries that are regulated, like the home care industry, it's because they have to comply with requirements set upon them by the administration. And obviously, employers are concerned about violent felonies, but also non-violent felonies. And so Ban the Box is a campaign that focuses on removing the checkbox that usually asks an applicant about their criminal history. Have you ever been convicted of a crime? Have you ever been arrested? Yes, no. Those are the checkbox that are referred to here. Currently, there are 6 states in which a legislation has been passed where employers cannot ask those types of questions at the application stages, and they're shown here on the map. Hawaii, interestingly enough, was the first state to ban the box in 1998, and it was then followed by Illinois, Massachusetts, Oregon, Minnesota, Rhode Island, and Washington, D.C. So if you're in any of these 6 locations, you're already probably very familiar with Ban the Box. Also of note, there are 12 localities around the country that have instituted some form of Ban the Box. Counties in Maryland, the city of Baltimore, the city of Buffalo in New York, the city of Rochester in New York, Philadelphia in Pennsylvania, Chicago, and San Francisco are the main ones. So be sure that you are aware of what your local requirements are, and also know that this campaign to ban the box is expanding to other states and localities. So why is there such a push for banning the box? Well, these are some numbers here, crime statistics. On the left side, you can see a graphic representation of the distribution of the U.S. population by race. And what about 60% of the U.S. population self-reports as being white, a little over 10% as being black, which is the light blue on the left, and about 14 to 15% as Hispanic. But when you look at the same statistics for criminal defendants, you see that the racial picture is very different. So black and Hispanic are disproportionately more likely to have a criminal history. And so because of that disproportionate impact on minorities, that is the reason for that push of Ban the Box. And the EOC has taken that banner, the EOC being the Equal Employment Opportunity Commission, has issued some best practices. And let me just say here that it's not a legal requirement, but the EOC does do audits, and if you follow some of their best practices, they look more kindly on employers who do. So one of the mainstay of the bandbox best practice is basically clearly employers still need to do criminal background checks, but don't do it at the application form, at the application stage on the application form. Do it maybe after the first interview if you're really serious about pursuing a candidate. Something that is good practice everywhere, I think, is to focus on conviction and not arrest records. In some cases, employers do ask if somebody's been arrested before, but there's so many reasons why somebody might be arrested. They might be arrested and released, but they still have an arrest record. So it's just probably not relevant to the employment. Also, on your application form, I would suggest that you avoid the blanket exclusion of "we do not consider anybody who would have a felony or a criminal conviction." Those blanket exclusions is really something that the EOC do not like. And the final recommendation from the EOC is to establish job-related criteria for how you're going to use the background checks. And I'll say more about this in a minute. So what does this mean for home care providers? If I take the example of the state of Virginia, which I know particularly well, the state of Virginia actually does not require home care providers to do the background check as part of the application process. It just says that it has to be done within 30 days of employment. But while the results of the background checks are waiting, the new employee cannot work in direct patient contact alone, but they can work under the direct supervision of another employee whose background check has, is clear and satisfies the licensure requirements. So for home care providers, it is true that certain felonies and misdemeanors will disqualify an applicant from employment. Anything related to abuse or neglect are, serious barriers, and employers need to know about that. Other criminal convictions, although not desirable, do not strictly bar somebody from employment. Narcotics, prostitutions, clearly not desirable attributes in an employee do not bar them from a regulatory standpoint to become a home care giver. So in the other considerations for employers is make sure that the what you need to check is basically that the offense do not involve abuse and neglect, and that the timeline, usually about 5 years, has lapsed since the last conviction occurred. So in terms of implementation for home care providers, obviously keep up with changes that might come up with your state or your localities. Consider removing questions regarding criminal background on your application form. Definitely remove any questions related to arrest record, and maybe establish a selection grid for yourself and for people who do recruitment for you in the office. And what I've put there is really an example, something to think about, to help you think about it, is, clearly in home care you've got those people who work with direct contact with client, and then you have your office staff. They do different types of jobs, and in terms of criminal convictions, you probably have different requirements. So for instance, the crimes of abuse and neglect in Virginia, it's a 5-year bar. So that's, you can't go less than that. And then for office staff, you might want to consider whether you're going to put some sort of criteria. Other crimes and felonies such as theft, narcotics, or DUI are other things that you might want to consider when you establish your criteria for selecting somebody out of the recruitment process. Tony, any questions on Ban the Box?
We got one here. It's can you legally not hire a person who has anything that shows on their record, misdemeanor arrest record, or federal, no matter how far back it goes?
I'm not an attorney, but I think, and again, you would have to check what are the licensure requirements, if any, for your state, because that's usually where those requirements are set. But I could not think of a limitless time as being something that would meet muster if somebody was to challenge that in court. It has to be reasonable, and it has to be job related. Those are the two criteria that are often used.
Gotcha. All right, so yeah, this brings us to our last point, and the one that affects everyone, the Affordable Care Act, or Obamacare as the better known name. So what is it, and who needs to be concerned about it?
Right, and often when you hear about the Affordable Care Act, you hear another little catchy expression, which is play or pay. And in many sense, it's kind of the third shoe. I know this is kind of a weird image to drop for the home care providers. You've had exemption, the end of the exemption for overtime for the caregivers. You're going to have the change in the overtime threshold for your office staff, and starting last year in 2015, you've had to start thinking about medical insurance and whether you wanted to play or to pay. So to play means basically you're going to go along and offer medical insurance. So employers with at least 50 full-time equivalent employees have to offer medical insurance. The full-time hours here is different from the overtime full-time hours, just to keep it really interesting. An employee is considered a full-time employee if he or she works at least 30 hours a week. And if you're offering medical insurance, it has to be affordable, which means no less than 9.6% of income. And it has to be a quality coverage, which is minimum 60% of expenses are covered for a standard population. So that 60% is something that is established by the actuaries, and the broker or the health insurance provider will tell you, this is a bronze plan, 60%, this is a silver plan, this is a gold plan, this is a platinum plan. So they've used different metal colors to distinguish between the different types of coverage that each plan offers the employees. So that's if you decide to play. If you decide to pay, it means paying the penalty for not offering medical insurance. This year, in 2016, the penalty is going to be $2,160 per year per employee for any employee over 30 full-time equivalent. And I'm going to go, in the next slide, I'm going to explain what full-time equivalent is. So just hold your thoughts for a minute. And the penalty is assessed by the IRS on a monthly basis. So for each month where you should have offered the plan and you did not offer medical insurance, you will be charged 1/12 of $2,160. So again, what does this mean for you, the home care providers? First of all, you need to know how many full-time equivalent employees you have. When you talk about full-time equivalent, you're considering staff and caregivers. And basically what you do is you add all the W-2 hours in a worked week and you divide it by 30 hours. So in the example that I've put in on the slide here, you see that in week 1, you have 6 employees that worked a full-time equivalent of 5.7 employees, so less than 6. But in week 2, there was an increase in workloads, and they work actually the equivalent of a little over 7 full-time equivalent employees with the same 6 employees. So that's why the full-time equivalent calculation is important to do, and you have to do it on a weekly, monthly basis to really keep track of it and see whether you are subject or not to the Affordable Care Act. So the first thing you determine is to know whether you are subject to the Affordable Care Act. So if you have less than 50 full-time equivalent, which is basically 1,500 hours of W-2 time, you don't have to worry about the Affordable Care Act. You're below the threshold. If you're over 1,500, you are subject to the Affordable Care Act, and you need to make some decisions. One of the first things to know is out of your employees who work at least 30 hours, how many are actually interested in getting group health insurance? And once you know how many people are likely to take you up on your offer of health insurance, you'll be able to contact the benefit brokers and get some quotes on as to how much it's going to cost you to insure your population. If some of your employees do not want, although they are eligible for it, but decide that they don't want insurance from you, make sure that you make them sign a waiver. And the waiver has to show that you've made an offer of medical coverage, that it was affordable, and that the employee declined it. The reason why you want to have a waiver is in case it's challenged, you're able to, if you're asked to pay, if the IRS comes back and asks you to pay, you'll have to be able to defend yourself, and the waiver is one piece of evidence that you'll be able to use. Tony, do we have time for another poll question?
Yeah, real quick, we'll put that poll question up here.
Okay, so it's a poll question related to the Affordable Care Act. And again, you've got 5 possible answers. How does your agency meet currently the requirements of the Affordable Care Act? So option A is you are subject to it and you have decided to offer medical care. Option B is you're subject to it and you have decided not to offer medical care insurance. Option C is you're not subject to it and you do not offer medical care insurance. Option D is you're not subject to it and you do not offer medical insurance. And the last one is you haven't not made a decision yet.
All right, so we got 60% of the voting in right now. We'll just give another second here. I know we're at the end of the webinar here, so we'll wow, it's been a quick hour. You're sharing a lot of great information here. Time flies. I thank you for staying on a little bit longer with us too, Anne-Lise. I appreciate it.
Right, no problem. I just want to make sure we cover everything and people have what they signed up for. So looking at the result, it looks like option D is by far the main situation, which is that you are not subject to the Affordable Care Act and you do not offer medical insurance. Okay.
Yep.
So for those who are subject to the Affordable Care Act, know that starting this year, the health exchanges or the marketplaces will send notification to employers when somebody claims a tax credit when they buy health insurance. And so at that point, you will be asked to pay a penalty unless you can prove that that the employee did not qualify for medical insurance because they worked less than 30 hours consistently, or that the employee waived the benefit that you were offering, or in some cases the employee may not qualify for a tax credit because their income level is high enough. So those are the 3 areas that you need, one of the 3 that you'll need to have to be able to defend against those penalty claims from the IRS. And I know they haven't really come yet, but the system is now in place, and I know they're planning to send those notices. So you'll probably be surprised the first few that you get, but unfortunately that's going to be probably coming more consistently over the next years. So what has the experience of employers been regarding Affordable Care Act? Some employers have decided to play and offer insurance because it's good business to have healthy employees. It's the right thing to do, and they know that the penalties will increase every year, so why pay a penalty and not get something for it? However, the take-up rate has been low in the retail service sector. About 5 to 10% of blue-collar, lower-paid employees have actually decided to take medical insurance. In some cases, and some of my clients fall in that category, they've decided to pay the penalty because they've come to the conclusion that there is more to the cost of healthcare than just the cost of paying the premium. There's also the cost of administering the healthcare, and it just is an added complication. They didn't want to deal with it, with the added twist that some of their lower paid employees would probably be much better off getting insurance on the marketplace with tax credit than they could ever be able to afford through an employer-sponsored health insurance. So it's really a mixed bag. I think it's still a little early to tell what will happen in the end, but when it comes to the home care industry, I think health insurance it is not a widely offered benefit at this time. I think that's a fair statement to make, and it's reflected in the results of our poll. So this is the end of the webinar, and thank you so much for staying on. I have a couple of gifts for our audiences today. For those of you who are interested, I will send you my white paper, which summarizes my experience and the experience of others on implementing overtime in the home care and how that, and some ideas to help you along the way. The second gift is also my offer to schedule a 30-minute consultation to get some answers to your HR problems. It's not going to be a sales call, I promise. I'm not going to try to give you fluff, or, you know, I'll answer your questions for 30 minutes and hopefully that will be helpful to you. And on the screen you can see a couple of ways to contact me through phone or email. Tony, over to you to close the...
Anne-Lise, thank you so much. You know, we really appreciate you again for staying on, for being on today and staying on a little bit longer than normal. Guys, we will send out Anne-Lise information in an email, so you have that if you didn't catch it. Real quick, before we jump off, would like to remind you about the upcoming boot camp. We do have a few spots left. It's going to be February 11th, 12th, and 13th in Phoenix, Arizona. We're going to talk about how you guys can effectively increase your rates and grow your business in 2016 through your marketing, direct marketing efforts. It's going to be amazing, amazing, amazing event. I'm extremely excited for this boot camp. We have a great special guest speaker, father of quarterback Drew Bledsoe. Mac Bledsoe will be there talking about his foundation with Parenting on Dignity. So we're really excited to have him as well. So again, I want to thank all of you guys for joining us today. I want to thank Anne-Lise for presenting for us. We're very appreciative of that, for you sharing your HR expertise with us and helping our people prepare their HR systems for 2016 and beyond. So again, guys, feel free to reach out to Anne-Lise if you have any questions, and we'll catch you on the next webinar. Have a great day.
All right. Thank you, Tony. Have a good afternoon.
You too.